In our daily lives, we often encounter situations where one person promises to protect another from a potential loss or harm. This promise forms the basis of what is known as indemnity. Imagine you lend your friend your car and they accidentally damage it while parking. If your friend promises to cover the repair costs, they are essentially indemnifying you against any financial loss. Indemnity provides a safety net, ensuring that the individual who might suffer a loss due to a specific event is compensated for it. This concept is particularly relevant in legal and commercial contexts, where agreements often involve potential risks and liabilities. Think of a construction project where a contractor agrees to indemnify the owner against any claims arising from accidents on the site. This promise of protection offers peace of mind and allocates responsibility for potential losses. Overall, the concept of indemnity plays a crucial role in various aspects of our lives, from personal agreements to complex business transactions, by providing financial security and clarifying liabilities. The Indian Contract Act, 1872, lays down the legal framework for various agreements, including the Contract of Indemnity. Section 124 of this Act specifically deals with this concept. It defines a contract of indemnity as a contract by which one party promises to save another from loss caused by the conduct of the promisor himself or by the conduct of any other person. Let's break down this definition. There are two key parties involved: the indemnifier or promiser and the indemnified or promisee. The indemnifier promises to protect the indemnified from any loss or damage. This loss could be a result of the indemnifier's actions or the actions of a third party. For instance, if A promises to compensate B for any loss B may suffer due to a legal suit filed by C, it constitutes a contract of indemnity. Here A is the indemnifier, B is the indemnified, and C is the third party. This contractual agreement ensures that the indemnified party is not left bearing the burden of a loss that they were promised protection from. Like any other contract, a contract of indemnity also needs to fulfill certain essential conditions to be legally valid and enforceable. Let's delve into these key features. Firstly, a contract of indemnity must involve two distinct parties, the indemnifier and the indemnified. Both parties should be competent to contract, meaning they should be of sound mind, major, and not disqualified by law. Secondly, there must be a valid promise from the indemnifier to compensate the indemnified for any potential loss. This promise should be clear and unambiguous, specifying the extent of protection offered. Thirdly, the contract should clearly state the conditions under which the indemnity will apply. This includes defining the specific events or circumstances that would trigger the indemnifier's obligation to compensate. Lastly, a contract of indemnity can be either express or implied. An express contract is created through clear written or oral communication, while an implied contract is inferred from the conduct or relationship of the parties involved. For a contract of indemnity to be legally sound and enforceable, these essentials must be present, ensuring clarity and mutual understanding between the parties. Contracts of indemnity can be classified into two main types: express indemnity and implied indemnity. Express indemnity involves a clear agreement, either orally or in writing. Implied indemnity arises from the relationship or conduct of the parties. Understanding these types is crucial for determining rights and obligations. Section 5. Legal enforceability and scope of indemnity. For a contract of indemnity to hold weight, it needs to be legally enforceable. This means that the contract must comply with the general principles of contract law, including free consent, lawful object and consideration. The scope of indemnity refers to the extent of the indemnifier's liability. It outlines the specific losses that the indemnifier is obligated to cover. This scope should be clearly defined in the contract to avoid any ambiguity or disputes later. For instance, if a contract states that the indemnifier will cover any and all losses arising from a particular event, it indicates a broad scope of indemnity. Conversely, if the contract specifies the types of losses covered, like legal fees or property damage, it represents a narrower scope. The enforceability and scope of indemnity are crucial aspects that determine the legal protection offered to the indemnified party. A well-drafted contract with a clear definition of the scope and adherence to legal principles ensures that the indemnity is legally sound and enforceable. Section 6. Rights of the indemnified party. When a valid contract of indemnity is in place, the indemnified party enjoys certain rights that protect their interests. Firstly, the indemnified party has the right to be compensated for any loss they suffer due to an event covered by the indemnity. This includes the actual loss incurred and any expenses reasonably incurred in trying to mitigate the loss. Secondly, if the indemnified party is sued by a third party for an event covered by the indemnity, they have the right to call upon the indemnifier to defend the suit on their behalf. This means the indemnifier is responsible for handling the legal proceedings and bearing any associated costs. Thirdly, the indemnified party has the right to recover any costs or expenses incurred in enforcing the indemnity contract itself. This includes legal fees and other expenses incurred in pursuing a claim against the indemnifier. These rights ensure that the indemnified party is not left financially disadvantaged due to an event for which they have been promised protection. The contract of indemnity acts as a safeguard, allowing the indemnified party to seek recourse and recover their losses. Section 7. Liabilities of the indemnifier. While the indemnified party enjoys certain rights, the indemnifier also shoulders specific liabilities under a contract of indemnity. The primary liability is the obligation to compensate the indemnified party for any losses covered by the contract. This means the indemnifier is financially responsible for making good on the promise of protection. Furthermore, the indemnifier is liable to defend any suit brought against the indemnified party for an event covered by the indemnity. This includes bearing the legal costs and any damages awarded against the indemnified party. However, the indemnifier's liability is not absolute. They are only liable for losses that fall within the scope of the indemnity as defined in the contract. For instance, if a contract only covers losses due to fire, the indemnifier would not be liable for losses caused by theft or flood. Additionally, the indemnifier is not liable for losses caused by the willful misconduct or negligence of the indemnified party themselves. Understanding the liabilities of the indemnifier is crucial in defining the extent of their responsibility and ensuring that the contract is fair and balanced. Section 8. Importance of indemnity in real-life situations. Contracts of indemnity play a vital role in various real-life situations, providing a safety net for individuals and businesses alike. In the business world, indemnity contracts are commonplace. They are frequently used in construction projects where contractors indemnify property owners against liability for accidents or injuries. Similarly, insurance contracts are essentially agreements of indemnity where the insurer agrees to compensate the insured for covered losses. Indemnity clauses are also common in contracts for the sale of goods, protecting the buyer from losses due to defective products. In financial transactions, guarantees and letters of credit often contain indemnity clauses to secure lenders against potential defaults. Even in personal dealings, indemnity agreements can be beneficial. For instance, a co-signer on a loan agreement typically indemnifies the lender, promising to cover the loan if the primary borrower defaults. The use of indemnity contracts brings clarity to agreements, allocates risks, and provides a mechanism for recourse in case of loss. It fosters trust and encourages parties to engage in transactions they might otherwise hesitate to enter. Section 9. Conclusion. The Contract of Indemnity, as defined in the Indian Contract Act 1872, is a crucial legal instrument that provides protection against potential losses. By understanding the meaning, essentials, rights and liabilities associated with such contracts, individuals and businesses can safeguard their interests and navigate various transactions with greater confidence. From construction projects to insurance policies and financial agreements, indemnity clauses are woven into the fabric of numerous legal and commercial activities. By clearly defining the scope of protection and adhering to legal principles, parties can ensure that their contracts are enforceable and offer genuine security against potential risks. As we navigate the complexities of modern life, a firm grasp of the concept of indemnity proves invaluable in protecting our interests and fostering a climate of trust and accountability in our dealings.